And how often do you talk to them, to your siblings?
We don't talk all that much. We talk occasionally if there's some kind of a family situation going on, but we don't generally just, well, personally, I don't generally pick up the phone and call them. I maybe call my brother a little more, but we generally don't just kind of pick up the phone and chit chat. It's usually about some family related thing.
Okay. And what's your mother's name?
My mother is Peggy Husky.
Okay, and how often do you see her?
Pretty much the same. It's all kind of family related.
Okay. And where does Peggy live?
She lives in Houston on the north side of town.
Okay, and do you also live in Houston?
I do.
About how far from Peggy do you live?
35 minutes, I think.
And how often do you talk to your mom?
How often I talk to her? No, I probably talk to her, a couple of times a month, 3 or 4 times a month. I mean, it ranges. It could be once a month or it could be 3 or 4 times a month. Just depends on what's going on.
Okay. And it's true that your mother and father were divorced, correct?
That's right.
Do you remember what year they divorced?
I think it was around 1976, 77.
And how old were you?
I was 13 or 14.
Okay. Do you remember much before the divorce?
Long time ago, but I generally remember what was going on.
Okay. And do you remember hanging out with your dad before your mom and dad were divorced?
Yeah, we hung out, mainly family things. He coached me in basketball. I played quite a few sports and he was around in those sports, but he also worked quite a lot.
And after the divorce, did he continue coaching you in your sports?
No.
And are you currently married?
I am.
Okay. And when did you get married?
I'm sorry, I'm all hunched over here. Let me see if I can do this up here. Okay, I'm sorry, go ahead.
Sorry, when did you get married?
I got married in September of 1995.
And what is your wife's name?
Chrissy.
Chrissy without a T, correct?
Yes.
Okay. Just want to make sure I have the names right between your
I get confused too.
Okay, so you were married in 1995 to Chrissy. And how long did you guys date for?
Oh, a little over 2 years.
So you met her in or about 1993?
That's correct. I met her in June of 93. We married September of 95.
In between 1993 and 1995, did you ever introduce Chrissy to your dad?
Of course.
How many times did your dad meet Chrissy before you got married to her?
Okay, so we were living apart. I mean, she lived in Portland, Oregon, and I lived in Houston, Texas. So he met her right away.
Okay. And do you and Chrissy have children?
We do.
And what are their names?
4 daughters. The oldest is Peggy, and then Mary, and then Theophany, and then Georgia.
And are those family names?
They all are, yes.
So we're here today to talk about your dad and his will, correct?
Correct.
How would you describe your father?
I would call him a good man and a tough guy.
Have you ever been described to be like him?
Yeah, on occasion.
Do you believe that you're a good man, but also tough?
I think so.
And we talked a little bit about you as a child with your dad and then after the divorce. Once you turned 18, did your relationship with your dad change at all?
Let me just go back. I think it changed when we got divorced. And then that's where the change primarily occurred at that point in time.
And okay, did you go to college? Obviously, you're a lawyer.
I did. I went to Texas A&M University.
And while you were in college, did you talk to your dad at all?
Yeah, I mean, sporadically. Just sporadically.
Did he help you with your college?
He did.
Okay. Is that financially?
That's correct.
Did he ever ask you to pay back his financial assistance for college?
No.
And in college, you said you spoke sporadically?
Yeah, yeah. I mean, he'd come up to A&M once or twice with maybe part of the Greek Association, student union or something. We met. My sister was at A&M as well. So she might have a better recollection of how much he came to see us up there, but, yeah.
And did you go to work after you graduated from college?
I did. I spent 1 year at, Allied Bank of Texas here.
And then you went to law school after that 1 year of working?
I did. Went to University of Houston.
What made you decide to go to law school?
So I was just going to get out and get a job. So I got a degree in finance with a specialization in real estate at A&M. My dad had helped us go to college, and I kind of figured that was the end of it. I need to get a job on my own. And so I got a job out of college. But during spring break of my senior year, my dad asked me to go have lunch with him and David Mintzberg, good friend of his. He's a lawyer and basically a real estate investor. And I think it was a partner with my dad. They took me to lunch, and David basically wanted me to do what he did. He thought it'd be a good idea. So he said, why don't you go to law school? And my dad was supportive. And I said, hey, if you're supportive of me going to law school, I'm going to take you up on it.
And when you say supportive, what does that mean?
Well, I had gone to A&M and did well, and I didn't have to worry about finances. So I was able to study all the time. And I kind of figured that if I was going to go to law school, I personally kind of wanted the same scenario because I wanted to do well. I didn't want to just go in there and struggle. So I had my choice. And so, yeah, so he said he would support me. So I felt like that would give me the opportunity to do well.
I'm going to object to hearsay. It's gotten kind of a little ahead of me, so objection to hearsay.
Sustained.
Did your father financially assist you with law school?
He did.
Okay. Again, did he ever ask you to repay him for that financial?
He did not.
And just for Ms. Cook, please I'll try to let you finish. Please let me finish. He's typing very quickly.
I see.
Okay. Did you ever work with your father directly, either in college or law school?
In college, I spent at least one summer with him. I think it was probably one summer. I don't think it was two, but I could be wrong.
And did your father attend your college graduation?
He did.
And what year was that?
1985.
And did he attend your law school graduation?
He did.
What year was that?
1989.
Did you see him at all while you were in law school?
Yes. And so because I was in town, my dad had Rocket season tickets, and he often asked me to go with him. In addition to that, I was playing, you can call it intramural, but I was playing sports with the AHEPA organization all over the country, and he would attend some of those tournaments, whether it's basketball or softball.
And what is AHEPA?
The American Hellenic Education Progressive Association.
And you said you worked for him. Were you ever in the real estate business with your dad? Did you ever join a partnership with him or anything?
Yes, when I worked with him, I just was, I was just doing almost go for work. He was in the real estate business. I was driving around looking for properties that he might want to purchase or lease or even list for sale. But I did join, he called me, I want to say early 90s, and asked me if I wanted to join him.
Hearsay.
Sustained. I joined him in a part.
Okay. When I sustain an objection, that means we all stop and the other side gets to ask another question.
Sorry.
That's okay.
Were you ever in a business venture with your father?
Yes, I was.
And what year did that start?
I want to say the early 90s.
Do you know when that business venture wound up?
I want to say in the late 2000 teens. So I want to say around 17, 18, 19.
And did you and he, without telling me what you communicated about, did you and he communicate or correspond regarding that partnership?
Certainly, yes.
Was that via phone or email?
Well, throughout the life of the partnership, the partners met in person. We also talked by phone. We also email. I don't think we did much text.
And you testified that your dad did attend your wedding, correct?
Yes, he did.
Did he ever meet your children?
Yes, met all my children.
And what year was your oldest child born?
1999, September,
And what year was your youngest child born?
August of 2005.
And your testimony is that your father met your youngest daughter in August of 2005?
Oh, certainly, yeah.
Was he there at the hospital when she was born?
I'm almost certain he is. He was at the hospital for all the births, as far as I recall.
And throughout the lives of your 4 children from 1999 to 2005, did your dad visit with them?
He did.
Okay. How often did your dad see your kids?
Well, certainly around the holidays. One thing we didn't do is, well, I don't think we spend many holidays with him exactly on the holiday. I think we generally spent holidays with my mother. So we would see him around the holiday, whether it was a day before, day after. So primarily the holidays, and I think he might have attended some preschool type functions, yeah.
And what year did your dad stop attending those functions?
It would have been George's first birthday on August 31st of 2006.
Okay, and so August 31st, 2006 is the last function that you remember your dad being at for your children?
That's the first one that I remember he wasn't at.
He was not at,
Yeah.
okay. So what was the last one that he attended?
I want to say Theophani's birthday in July of 2006.
And you're sure your dad was at that birthday party?
I'm pretty sure. There's been some reflection going on. So, yeah.
And when your dad attended these birthday parties for your kids, did he bring anybody?
Yeah, during that period of time, I don't know if it was the entire time, but a lot of that time he was, as we've heard, he was dating Victoria and she was generally around.
Okay, and did Victoria attend your family functions?
She did.
And so is it fair to say then as late as potentially July 2006, Victoria was attending family functions?
I don't think she was attended that one. No.
When's the last time that you remember?
I don't recall. It seems to me it was 05. Yeah, but
And how would you describe your relationship with Victoria?
cordial.
Actually, relevance?
I'm gonna.
Okay.
She was friendly with my kids. She was respectful of me.
Did you know if your dad was dating somebody in 2006?
I did not.
And you've heard testimony today that Lisa was dating your dad prior to 2006, is that correct?
I have.
Were you aware, when did you find out that Lisa was dating your father?
Yeah, I think it was right around that time, late July. I could be wrong, but something tells me it was in July-ish of 2006.
And did you discuss this with your father?
I did.
And again, without going into too many details of what was said, how did you try to talk to him about it in the phone, in person? How did you try to talk to him about it?
I think we set up a meeting at a place called Pumpkin Park.
And what year was that?
It was 2006.
And generally, how did that conversation go?
I would,
Part about the conversation straight through on hearsay.
So it's sustained. If you could make the question a little more precise to not potentially solicit hearsay.
In your opinion, how did the conversation go with your dad? Without saying anything that he said.
yeah, it was rough. It was rough. It was argumentative. It was antagonistic, you know.
And soon after that, is it true that your dad wrote you a letter?
He did write me a letter.
Judge, may I approach?
You may.
And these. I'm handing our Mark LP 9 and 10 that were lead to admission on Friday.
Sorry, these are marked, which exhibit?
Did I know which one is which? And
LP 9 is the letter from the student to George. LP 10 is George to the student. It's your exhibit markings under the list.
all right, thank you.
And if you look at the exhibit mark 9,
Yeah.
can you describe what that is to the jury, please?
Yes, this letter was sent to me on December 24th of 2006. My dad was sending me the letter. He was congratulating me for being reelected to the board at church. But he went on to say that the purpose of our meeting was to work out a compromise solution to our separate issues and viewpoints. And he goes on to explain various things.
So if we stop right there, your dad said that you wanted to work out a compromise solution. How did you feel about that?
It's kind of what Dad would want to do, the way he wanted to, how he functioned.
Your dad also goes on to say that you were full of hostility, anger, and resentment, correct?
He does. He does.
You said that that was. And Judge, we're going to put the exhibit onto the, and object to the jurors unless there's an objection.
There's no objection. You may so.
We'll
Oh,
the
okay.
jurors see what.
Pull the buttons again.
I don't know why it's not working there. Not coming up any, is it coming up?
No.
Yours? No? Clicker over here.
Our screen appears to be on. It's like not totally black. It's just nothing.
Right.
No light is on here. Yeah.
Wondering. May require a full-on reset, I don't know.
Judge, may I publish with paper?
You may publish with paper, yes. And during the break, I'll go and. That's, yeah, you can, the HDMI cable for the, yeah, it needs to be plugged into the document camera where it works. There's a plug in, are you gonna try to use the document camera?
No. I wasn't sure if yellow would be off. In
Oh, no. No, it's not even.
Okay, because I do have the HDMI cable plugged into my. Here, this isn't.
I did have two extra.
It started to, it goes, oh, there it went, what happened?
All right.
There we go. Okay, fine.
And so your father is somewhat summarizing your call with him, correct?
Yeah,
I'm sorry, did you make an objection? Sustained.
George, can you give the jury a summary of what your dad was trying to express in this letter?
Yeah, he wanted to let me know how I was feeling, and he wanted to let me know how I should learn to feel different about the situation.
Was that typical of your father?
Pretty much.
And was it typical of your father to approach a situation like this, telling you that he wanted to approach a compromise?
Yeah.
And how did that make you feel?
I mean, that's the way Dad was. He was a business guy, and you know, it didn't necessarily bother me. I mean, that's not the way I do business, but that's the way he wanted to do business. So, you know, I just roll with it after that.
And if you go down to the last paragraph on that page that starts with "I realize," can you read that to the jury?
I realize I cannot change you or your feelings about the matter. They are yours and yours alone, and only you can change from the inside.
And it goes on to say the rest of that paragraph.
I can't change you from the outside, nor do I want to try.
Do you take that to mean that your father wanted nothing to do with you?
No, my dad gives advice all the time. And this was one piece of advice that he wanted to give me. And he again, he wanted me to change. And that's how he wrote it.
Do you think your dad was stubborn?
Stubborn?
Yes.
Yeah, yes.
Do you think you're stubborn?
Yes.
And if you go to page 3,
Mhm.
and it's the third full paragraph down. Can you read that to the jury, please?
Beginning with I've.
I found.
Okay. I've found peace in my life, and I will continue in peace and not in anger. I want to reiterate, I'm sorry for all the hurt feelings you feel. And only hope you get help to work through them. Arguing with me only keeps embers burning and not allowing you to reach forgiveness and or release of these feelings.
How did you understand that paragraph? What do you think your father meant by that?
Yeah, I mean, it's kind of a forgiveness thing, you know, that I needed to, you know, he was moving on with, he wasn't going to feel bad about it. And he wanted, you know, he wanted me to forgive and get over it.
And if you go to the next paragraph, could you please read that to the jury?
I love you and all your family. And your brother and sisters, and care about them too.
Did you ever have any sense that your father did not love you or your siblings?
No, no.
And finally, could you take a look at the last paragraph on the last page that starts with "take care"?
Okay, the last paragraph, sure.
Could you read that out loud, please?
Sure. Take care of yourself. The Christmas pictures are unbelievably beautiful. You need to be extremely happy for having a beautiful family. You need to verify your road map as to not get caught in my tracks.
And you received this letter on Christmas Eve, 2006 or thereabouts?
That's the day it was dated. That's what date I got it.
Okay. And when you received this letter, how did you feel?
It was tough. It was tough. You know, we just saw things differently.
Did you feel like you didn't love your father after that letter?
No, I always loved him.
Did you ever stop loving him?
No.
And you did respond to that letter, correct?
I did.
And if we could publish LP 10. And what appears on your screen is that, does that look like the envelope?
That's my envelope.
Okay. Are you surprised that this envelope is surfacing today?
Yeah, I didn't recall this, so.
And you didn't recall the letter?
My response.
Okay, so does it appear that your dad kept your letter and the envelope that it came in?
Yes.
Does that surprise you?
No.
And if we go to the first page of the letter, these are your words in your response to your father in 2006 or 2007, correct?
I don't think there's a date on this, but it was probably soon after I got it.
And so as you're reading this letter, it appears that you responded to your dad's letter point by point.
That's what it looks like.
And if you go to, were you happy to have to respond to your father's letter?
No.
Were you mad?
No.
Were you saddened by your father's letter?
Sure.
When you look at this letter, if you look at it, work out a compromise, could you please read that out loud to the jury?
Work out a compromise in quotes. In my response, this is not a business matter, but a family matter. They're distinguishable.
Why did you say that?
Because I'm stubborn.
Did it hurt you that you perceive this as a family matter? I'm sorry, as a business matter, and that your father was not treating it as a family matter?
Yes.
And you respond in kind, basically by bullet point throughout this response, correct?
Objection, leading.
Sustained.
If you look at a paragraph that starts with, "You have been in anger for 33 years," could you read that to the jury?
In quote, you have been in anger for 33 years. My response, you should not kid yourself into believing that what I feel today has anything to do with what occurred 33 years ago. As you are well aware, while it did take me some time to get over what occurred, with the few exceptions of your other aberrant relationships, you and I had a fairly civil relationship up until this latest situation.
And what was that latest situation?
His relationship and pending marriage to Lisa.
What caused that relationship, caused this level of strain between you and your dad?
My dad's relationship with Lisa?
Yes.
So when I first heard about this in July of 2006, I had heard that.
Objection, hearsay. Objection, hearsay. I had heard.
Sustained.
So you were upset about your father's relationship with Lisa, fair?
Objection.
Fair.
Leading.
Sustained.
Were you upset with your father's relationship with Lisa?
Yes.
What caused you to be upset without getting into anything anybody told?
They were getting married, and I'd never met her, and none of my siblings had met her.
But you had met previous girlfriends.
Objection, leading.
Sustained.
Had you met his previous girlfriends?
Yes.
Did you find it odd that you had not met Lisa?
Yes.
From 2006 to 2020, approximately, did you speak to your dad on the phone in that period?
From 2006 to 2020?
Yes, it's a large period.
That's a long period. It may have once or twice over that period of time. It wasn't, not many times.
But during a portion of that period, you testified that you were in a partnership with your dad or a business venture.
Objection leading.
Sustained.
Were you in a partnership during that period?
Yes, I was in partnership with him during that period of time.
And that's what you were testifying about earlier.
That's right.
Did you communicate with him regarding that partnership?
I did.
Did you communicate with him regarding any family issues between 2006 and 2020?
Yes,
Did you ever text him or email him or contact him regarding to wish him, happy Father's Day?
yes,
What about Merry Christmas?
I believe I did.
And when is the last time that you recall emailing your father?
I want to say in 2021.
And do you remember what that email communication was about?
Yes.
And Judge, I'd like to approach the witness with NAA pre-admitted on
Email.
Friday.
Yes, ma'am. 8A, you said? All right, thank you.
Mhm.
And I believe Ms. Michael will publish that. It's page 200 to. Sorry, 156 to 200 and 214 to 2. And can you generally describe what that communication is?
The communication we're referring to is my youngest daughter, Georgia, had been asked by the Greek national softball program out of Athens, Greece, to participate on their national team. To do that, she had to get Greek citizenship.
Did you email your father?
I did.
Why did you email your dad about that?
I believe my dad was trying to get Greek citizenship himself, and I didn't know what the status of that was and whether he could help Georgia get citizenship, and that we had engaged a lawyer in Greece and wanted to share that information with him about the lawyer we had engaged in Greece.
And does your daughter play for is it the Greek national team?
Yes, she does.
And did you generally, over the course in March 2021, how many times did you email with your father?
I don't know. I want to say it was 2, 3, I don't know, 4. It wasn't a lot. So I don't have exactly, but 3 or 4 probably.
Did the communication seem friendly?
Yeah, they were.
And based on the emails from him, did your dad seem happy to hear from you?
I think he was, I think it made him feel good.
Did you have any other communications with your father after this March 2021 email?
Probably not.
And during the 2021 email exchange, did you ever offer to assist your father with his Greek citizenship?
I believe I did, yes.
Did he take you up on that offer?
I don't think he pushed it after that period of time for himself.
Did you have any communications with your dad in 2022?
The only communication I had with him in 2022 is when I called him at the hospital.
Do you remember what day you called him?
I do not.
Were you able to speak to your dad?
It went to voicemail.
Did he ever call you back?
He did not.
And you were not at the hospital on February 9th, 2022, correct?
I was not.
Did you speak to your father on February 9th, 2022?
No, I didn't speak to him on February 9th.
Did you know that your dad was in the hospital in February 2022?
I did.
Okay. Did you know that he was in the intensive care unit?
I was aware he was in the intensive care unit.
How did you find that out?
My sisters.
Did your sisters generally keep you up to date about your father's status?
They did. Generally when there was a change in status.
And when did you find out that your dad was admitted to the hospital in January 2022?
I would have found out pretty much right away. They would have let me know.
Is it fair to say that your family has some sort of phone tree?
I'm sorry.
A phone tree where you get.
Yeah, a text tree. Yeah, I think so. Yeah.
And how did you find out that your dad was admitted to the hospital in January 2020?
It was likely a text message from my sisters.
And you testified that they gave you changes in status updates. How often did you get those?
I don't recall. Maybe it was weekly. Maybe it could have been sooner than that if there was some material change.
Were you worried about your father?
Worried?
Yes.
Yeah.
Did you know at any time in 2022 that your dad had executed a will while he was in the ICU?
No.
Did you have an understanding of how sick your dad was?
From what my sisters told me is what I knew.
What was your impression of your father's condition in January 2022?
My understanding was he was sick with COVID at home for a while, and that it was.
I'm gonna object to this hearsay. He never went and visited him. If he had any updates on his dad's well-being in the hospital, it would have been purely through conversations of somebody else. He has no personal knowledge.
If the witness does not have personal knowledge, I'll need to sustain the objection. I don't know that he has personal knowledge either. It sounds like he was getting updates from somebody else. Unless you can ask the question directly.
Well, and part of the problem, Judge, is good faith.
Is what?
The good faith and justice on showing, explaining his
I
understanding.
understand, but we still have to follow the rules of evidence. So if he did not have personal knowledge of this and could not have discovered it except through hearsay, then I have to sustain the objection.
Judge, I'm offering it not for the truth of the matter, but for the state of mind. His understanding.
No. Overruled.
So you called your father and left a voicemail as your testimony, correct?
Objection leading.
Sustained.
Did you call your father and leave a voicemail?
I did.
Did he ever call you back?
He did not.
So even though you didn't see your dad, you were keeping up to date on his condition?
Objection leading.
Sustained.
Were you keeping up to date on your father's condition?
I was being kept up to date.
And what day did your father pass away on?
The day before his 88th birthday, January 13th, 2023.
And how did you find out your father passed away?
My sisters.
And did you go to your father's funeral?
I did.
Did your kids go?
They did.
And your wife, did she also go?
She did.
And when did you discover that your father executed a will in the ICU?
It would have been late March of 2023.
And how did you discover that?
One day I just decided I'd go look in the probate records to see if anything was filed. And I found that there was a filing.
And when you looked at the probate filing, did you see the date that the will was executed?
I did.
And did that concern you?
Well, it was February 9th, and that concerned me
And why did that concern you?
because he was in the hospital. And I verified that was the time he was in the ICU.
When did you file your contest in this matter?
Late April, around April 25th, I think, of 2023.
And prior to filing your contest, did you do any investigation into your father's status on February 9th, 2022?
I'm sorry, his status in what regard?
His medical condition.
Yeah, so everything I learned about his condition was through my sisters.
But when you filed your contest, you had reason to believe that he lacked capacity.
Objection leading.
Sustained.
Did you have reason to believe that your father lacked capacity when you filed your contest?
I did.
And did you have any concerns that your dad was subjected to undue influence when the will was executed?
I did.
Why?
Well, Lisa was with them every day. There was,
Sorry, I'm gonna object again because there's no personal knowledge. He didn't see his dad, if it was hospital. Just, if he's basing on what personal knowledge does he have to make that statement?
I understand where you're coming from, and I'm going to sustain the objection unless you can establish some personal knowledge.
Suffice it to say that you did have concerns about undue influence.
Objection leading.
Sustained.
Did you have concerns about the execution of the will on February 9th, 2022?
I did.
Did you have concerns that your father was unduly influenced to execute the will?
I did.
And you continue to maintain this action?
Yes,
And do you believe that you brought and maintained this contest in good faith?
I do.
Have you ever had to deal with a critically ill family member before, George?
I have not.
Have you ever had an immediate family member die before?
I have not.
Did you ever stop loving your dad?
I never stopped loving him.
And what about your siblings? Do you love your siblings?
I love all my family.
And can you explain to the jury why you filed this contest?
Well, I filed this contest primarily because I don't think my dad had testamentary capacity. I think he was unduly influenced. I think the terms of the will did not look at all of what I thought and felt my dad would have done based on being his son for 59 years, leaving certain gifts that didn't make any sense, leaving substantially all of his estate to lease outright, having limited distributions to my brother and my sisters, who he would want to take care of, leaving cemetery plots that he got from his parents' cemetery and ones he acquired in the 80s, all to Lisa. He had a very complex estate that I don't feel he could understand what he was doing in the hospital and what it meant. you know, and where these assets would eventually end up.
Ask the witness.
Thank you. Ms. Smith?
I just have a couple of questions. Mr. Polidoros, what was it about your dad's relationship with Lisa that was different than his prior relationships with other women such that it caused such conflict?
Well, for me, the fact that she was younger than my sisters and younger than myself was very difficult for me. And I thought would be very difficult for my sisters. And, you know, I wanted to make sure that he understood how I felt about that.
Is there any way that Lisa treated you or your sisters that furthered that
Ms.
conflict?
Smith, can you check your microphone?
I'm sorry, I'm a little hoarse. It is on. I may just need to speak up. Do you need me to repeat the question?
No, I think I heard you. Nobody met Lisa until, at least I didn't meet Lisa. Well, I'm not sure I ever met Lisa, to be honest with you. I did see her once and when I went up to my dad and she was with him, and I assumed that was her. But my sisters hadn't met her before the wedding. I don't know if my brother had, but.
Was it ever your impression that Lisa did not encourage your dad to continue to foster a relationship with you or his other children?
Well, that was my impression.
And after you filed your contest, did your lawyers conduct discovery in this matter to obtain records related to the lawsuit?
Yes, a lot of discovery.
And did that discovery include medical records and Dan Pappas records and similar documents?
Yes.
Did you have an opportunity to at least look through or review some of the records that were produced?
I did.
And after you reviewed those records, what was your impression of your will contest that you had filed?
Well, I thought it completely supported what my view was when I filed this contest.
Pass the witness.
Thank you. Mr. Cook?
Mr. Polidorus, you said you work at a pipeline company
Yes,
and you are also an attorney, right?
I am.
It sounds like the relationship you have with your siblings, there's not a lot of chit chat, and it's just every now and then when there's something that you guys have to discuss, you talk about it. Is that right?
We're a family. We have our own lives. We're all in our 60s with families. So yeah, it's basically a familial relationship, and we talk about family.
And then after your dad died, there was a lot of text back and forth between and among you and your two sisters related to the will contest. Do you recall that?
Yeah, there were text messages for sure.
Like hundreds?
I'm sure.
I'll get to that in a little bit, but I do want to ask you about your mom. You referenced your mom, Peggy. Do you recall that?
I do.
Okay, and your mom remarried a man named Harry Husky. Is that right?
That's correct.
How long after your mom and dad divorced did Harry and Peggy get married?
Objection, relevance.
Overruled.
6, 7 years.
Okay, and you were not angry with your mom for marrying Harry Husky, were you?
No,
Okay, and you had a relationship with Harry?
I did.
And I would imagine you would have thought of him as a loved one. I mean, this is your stepfather, your mother's husband, correct?
That I don't know what those words were. I never have called anybody a step parent of mine because I had my own parents until I was 14 years old. So I always called Bill my mom's husband. Yeah.
And Harry died, right?
He did.
And Harry had children.
He did.
Yeah.
I was asking you earlier about Harry Husky. Do you remember Harry?
I do.
And Harry had children, right?
He did.
And these would have been your step siblings? Well, technically, wouldn't they have been?
Yeah, they were Harry's children, but yeah.
How many children did Harry have?
I don't know. 2 or 3. They lived in California up in the Northwest.
Okay. Do they have a good relationship with Harry?
I don't know.
Objection, relevance.
Overruled.
I think earlier you testified that it wasn't fair under the circumstances for your dad to leave the property the way he did. Isn't that right?
It was something to that effect.
Okay. And are you telling us true that it's not fair for a second husband to leave property to his wife?
So I'm not sure I said it wasn't fair. I don't think that was what I said.
Okay.
I said I don't think it was his intent to do that. It wouldn't matter. It wasn't fairness. The point wasn't about fairness. It was about what his intent was.
Okay. So again, what I'm asking you is, overall, it's not your testimony that it would be unfair for a husband who has a second wife, for the husband to leave everything to a second wife, right?
Objection, it misstates the witness's testimony.
I'm asking you.
Asking for his own belief. Overruled.
Would you restate the question, please?
Sure. What I'm asking you is, do you believe it's unfair for a husband who has children from a previous relationship? Let me finish. Do you believe it's unfair for a husband who has have children from a previous relationship to leave everything to his second spouse?
I don't think it's a fairness question, so whether it's fair or not fair, I don't really know about that.
Think it happens?
Oh, I think it probably happens. Yeah.
Okay, probably happens. Don't you know that it actually, don't you have specific facts related to a situation where this has happened before?
Objection, facts not evidence.
He's asking about the fact. Overruled.
Don't you have particular facts related to the situation where this happened in your family?
I actually don't have any firsthand knowledge.
Okay, then I'm going to ask you a question. Isn't it true? You have no firsthand, isn't it true that Harry Husky had children from a previous relationship? Isn't that true?
That's true.
And isn't it true that Harry Husky left all of his property to your mother?
I don't know that.
Isn't it true bill that did that was drafted by Monty Donaldson?
I have no idea who drafted that will.
And isn't it true that your sister signed as a witness to that will?
I have no idea. I've never seen the will.
Let's talk about your relationship with your dad. And is it fair to say that you saw your dad on occasion between 2007 and 2015 for about 5 times?
That's probably right.
Okay. And the last time you saw him in 2015 was when he asked you and the grandkids to meet at Maya's for lunch or breakfast or a meal, correct?
To meet him for lunch at Mia's.
Maya's, potato. He wanted to bring $5,000 to the lunch meeting to give to your 4 children. Is that correct?
That's correct.
And then he gave them the money, correct?
He gave me the money for them.
Okay. And that's the last time you ever met with your father again, correct?
In person, I think that's right.
Okay. So to be clear, so the jury knows and has an understanding of at least what your relationship with your father looked like. It was between 2007 and 2015, you only saw him about 5 times.
That sounds right.
And then after 2015, you never saw your father alive again.
Yeah, I may have seen him around, but I don't recall where.
Let's talk about how your dad supported you financially. I mean, as a child, your dad was there for you. He coached you on different teams, correct?
Yeah, mainly coached me in basketball as an 8 or 9-year-old.
Okay. And then financially, let's talk about financial support.
Uh-huh.
I'm sorry.
Uh-huh.
After you graduated high school, you went and got an undergraduate degree, correct?
That's right.
And your dad paid for all of it.
That's right.
Okay. And then after the undergraduate degree, you went and got a law school degree, correct?
That's correct.
And how many years was that?
Law school 3 years.
And Your dad paid for all of law school, correct?
That's correct.
Paid for your living expenses, right? Paid for your food during all that period of time, correct?
Not everything. I think I made money on summer internships that I used to pay for things, but generally speaking, he paid, he told me he would pay for that when he convinced me to go to law school.
Okay. You were invited to your father's wedding. Yes or no?
I may have been.
And you didn't go, correct?
That's right.
Because you didn't support it. Right? That's what you said.
There were several reasons I didn't go.
I'm asking you, is it true or not? Have you stated before that one of the reasons you didn't go to the wedding was because you didn't support it?
I think that I probably have said that.
And then you met Lisa at the funeral, correct?
I met her.
Isn't it true?
I think I went up to her at the funeral.
Okay, and go ahead, tell the jury. You walked up to her, gave her a kiss and said, sorry for your loss.
Pretty much something of that nature.
So you would attend your dad's funeral, but you wouldn't attend his wedding.
Do you want to know why?
No, they could ask you. You attended your dad's funeral, but you would not attend his wedding.
I already stated I had not attended his wedding.
Let's look at those letters. I think the jury has the letters. Do y'all have those letters?
One.
Are they just the one? Okay.
One.
Both of them. But I'm going to. I don't want to give the jury both documents unless they have they received both documents, Judge, or they have just received published one?
They only received the one because we couldn't get the technology working, so no, they've not received both.
Okay, Judge, do you mind if I publish both? And I apologize, I'm going to publish both together, just so I don't have that one.
Sure, and just to confirm, they've both been admitted in writing.
They
Yes.
both
Yeah,
do.
okay. I have that too, so I just confirming because mine is. Yes, you may publish both.
I think you characterized your dad's letter, we'll look at that, we're gonna look at it side by side. I think you characterized your dad's letter as your father trying to tell you how to feel. Is that?
I don't think that's how I characterize it.
I thought that's how you characterized it in front of the jury a while ago. My dad was trying to tell me how to feel.
I don't know what I said.
Okay.
I don't have.
Isn't it true,
Transcript.
isn't it true that you characterized this letter more as, my dad didn't want to be a dad anymore, he just wanted to be his own man?
Objection states the witness testimony.
That's not at all accurate.
That's not accurate.
Correcting it now.
No.
No, I asked you if you've done that before.
Oh, I don't know. I don't know if I've done that before. I don't think I said that here in this testimony.
No, that's right. I'm asking you, have you characterized it that way before?
I don't know. It's possible.
Okay. All right, let's go ahead and look at this letter, and we'll go blow by blow. The problem is that they may not be able to read it, so I want to review this. It says, this is the letter that your dad wrote. Dear George, Merry Christmas to you and your family. Also, congratulations are in order to be reelected board. You deserve it, and I'm proud of you. You see that?
I do.
Okay. And then you did go blow by blow. Your response at the top, you said, it is sad that I have to respond to your letter. Why would it be sad that you have to respond to your dad's letter with what he's talking about? Why is that sad to you?
Well, in my view, my dad sent this letter to me so that he could get things off of his chest and to frame things in a way that made him look good. I mean, that was kind of a typical situation. And so I just thought it was sad that I had to respond to it in that fashion.
Okay. Oh, I do want to point out, this is from you. You sent it directly to him by messenger. You see that, page 1?
I don't know what I did. I mean, if that's what that shows,
Yeah.
if that's what that shows, it's possible. But there's something different here, which I saw and I wasn't really sure.
Objection, not responsive. I just asked you if you sent this by messenger.
It's got 2 different addresses on here, so I'm not sure.
Directly non-responsive. Just ask you, did you send this by messenger to your dad?
Oh, I see. It says by messenger up here. Okay.
Yes. And then it looks like it came from your Mayor Brown, Rowe, and Law.
That's right.
That's where you work at the time?
That's correct.
Okay, so you're sitting in this office as an attorney who your dad paid for you to become an attorney, and you're responding to him with this letter.
That's correct.
Okay. All right, the very first sentence says, he says, the purpose of the meeting I requested was to work out a compromise solution to our separate issues and viewpoints. It sounds like your dad is trying to connect with you, doesn't it? Just yes or no?
No.
Oh. Then he says, during the first 5 minutes of the call, I surmised from your demeanor that you were full of hostility, anger, and resentment. After what does that say? After I can you read that? After I hung up, I realized my trying to approach a compromise with you is futile. Do you see that?
I do.
And then your response is, if you look out here, it says, work out a compromise on your letter. This is not a business matter, but a family matter. They are distinguishable. Why are you mincing words with your dad when he's trying to work out and resolve these differences between you? Why are you talking about you should have used a different word?
This was written, I don't know the answer to that question.
Okay. If you go down to the next thing, it says, I had to rethink it, your dad's all right. I had to rethink what I wanted to say to you. I called your office, your 2 cell phone numbers, on or about noon with no answer. And then your response to that was, it took you almost 4 hours to call me back. Is that a problem where your dad is taking some time to try to reformulate and try to get a response and to call you back? Is it a problem that it took him 4 hours to formulate a proper response to you?
Under the circumstances, I must have thought it was a problem.
Okay. You also told this jury that you were not angry when you wrote this. Is that still your testimony?
Did I say I wasn't angry?
I believe so.
Okay.
That's still your testimony?
You know, anger's come up a lot. I mean, I characterize it as upset.
Okay, objection, no response by you.
Sustain.
I just asked you, do you want to change your testimony? Were you not angry when you wrote this letter in response to your dad's letter?
I could have been.
Okay. And it says down here, I proceeded to talk to your sister, Christy, and we have worked out and resolved our differences. First of all, pretty clear that your dad and Christy were having differences at that time. Is that correct?
Objection,
I don't know.
valuation.
Oh, just based.
I think he would, I'm sorry, could you re-ask the question for
Sure.
me, please? Because I think I
Yes,
may have misheard you.
It says, I proceeded to talk to your sister Christy, and we have worked out and resolved our differences. So a plain reading of that statement by your dad indicates that even he and Christy were having differences at the time, correct?
Yes, according to what he said.
Okay. I think your response was, over here, I proceeded to talk to your sister Christy. We have worked things out. You said, this is misleading. You and Christy have not worked out anything regarding the latest situation.
And if you could slow down just a little bit. Mr.
Yeah, I'm sorry. So your dad sounds like he's trying to work out a resolution with Chrissy. Sounds like he's worked it out, but you're even denying that your dad didn't work out the resolution.
Not regarding this latest situation,
And let's talk about, what is the latest situation?
the marriage to Lisa.
Okay. So this was written in 2005? When was your dad's letter written?
December 24th, 2006.
2006. Was this after he invited you to the wedding?
I have no idea when invitations were sent or whether I even received one.
Okay. And it says down here at the last paragraph, I realize I cannot change you or your feelings about your feelings about matter. They are yours and yours alone, and only you can change them from the inside. I can't change you from the outside, nor do I want to try. He continues, I hope for your good health that it's time for you to work on your internal feelings towards me, as it's a poison for your system and will ultimately harm you. You see that?
I do.
And your response was, the poison in my system was put there by you. You see that?
That's right.
Okay. And the poison in your system, I guess, was that he was going to marry Lisa Polydorus?
No, it was more than that.
The next one says, loss by either me or you as a father or most husband is a loss. And then your response, that must have set you off, because your response to that was, along. I'm not even gonna read it. But you're talking about what has occurred and continues is premeditated, repeated, and continuous disrespect by you towards your family. This is, again, is referencing his relationship with Lisa?
Yes.
And it says, it is clear that you know what you are doing is disrespectful to your family, and you have gone to bed and woken each day for 2 years deciding what you should do. So I guess I'm assuming that your dad has been dating Lisa for 2 years, so every day he wakes up and he recommits this same sin?
That's what I wrote. And I didn't call it a sin, by the way.
Well, call it an abhorrent relationship a little bit. We'll talk about that in a second.
Objection to the sidebar.
Agreed. And then you're saying that because of the relationship, he has continued to disrespect the family, right? Right?
Yes, this was written on the date it was written.
Objection, non-response.
That's correct.
All right. Next, your dad talks about five stages of grief, and he says you're stuck. And then your response is, again, this may relate to an occurrence such as loss by death, but in no way applies to occurrences that continue each day. And then again, you say you're premeditated, repeating continuous disrespect. And each day you continue to disrespect all of us. Did I read that correctly?
You did.
Okay. Number 7. He says, you have been angry for 33 years. Do you see that?
I do.
Is that just your dad's interpretation of the relationship? Or, in fact, have you been angry for 33 years?
I've not been angry for 33 years.
Okay. And then you said that what your response to that is, you should not kid yourself into believing that what I feel today has anything to do with what occurred 33 years ago. As you are well aware, while it did take me some time to get over what happened, with the few exceptions of your other abhorrent relationships, you and I had a fairly civil relationship. You see that?
I do.
What does abhorrent mean?
I don't know.
You typed it.
That was, I generally know what it is, but I'd have to get the definition. I probably looked at the dictionary knowing but I think it's not normal, I guess, is kind of where it comes from, or not generally, it looks like maybe you have it there, not generally acceptable or something of that nature.
A person whose behavior departs substantially from the standard. Is that correct?
Yes.
Okay. So you're telling your dad that not only is this relationship with Lisa abhorrent, but apparently there's other relationships that your dad had that were also abhorrent. Right? With the few exceptions of your other abhorrent relationships. You see that?
Okay.
Right? So were there other abhorrent relationships that your father was involved with?
This is referring to probably one that I'm aware of.
Well, it says S.
I know what it says. Right now, I can remember one.
Then your dad goes on, when you reach the stage of forgiveness, you will be released and then be happy. And your response to that was, again, we're not a lost situation. And you go back to premeditated, repeated, and continuous disrespect is another loss. So I'm not sure that I will ever get out of your stage one. You see that?
I do see that.
Okay. And then 9, your dad says a good Orthodox Christian is taught continuously to forgive. You see that?
I do.
And then your response, there's nothing short of purely self-serving statement, nothing more. To go to the Christian card is about as low as your premeditated, repeated, and continuous disrespect. No one is asked to accept abuse by a parent. Do you see that?
I do.
So because your dad was dating Lisa, it raised to the level of abuse on you.
Objection misstates the evidence.
What? I'm reading soon.
And with-
I felt that it was abusive, yes.
Next. I'm sorry for all the mistakes and situations I've created in your perception, but realize they are my mistakes. They are hurting. They are history, and history does not change. You see that? Your dad wrote that.
I do.
And then your response was, what a joke. Was this an angry response, a non-angry response?
I don't know. It's been a long time ago.
Seems like an angry response.
I don't know. I mean, it probably was.
All right. And then what's interesting is that you had told him, you had told the jury that this was him trying to tell you how to feel. But the very next sentence you said, you either are or are not sorry, and this is not a day in history. Your disrespect continues. You just tell him again that he's being disrespectful of the relationship that he has with his children and committing abuse because he's dating someone. Right?
I don't, you want to ask a question? I'm sorry, I didn't hear a question there.
I did. I mean, just, this is the nut, this is, you just continue. I think you tell him again,
Yeah,
that this is not an event in history. Your disrespect continues daily. So you told him again, you're being disrespectful. That's what you said here again in this paragraph.
I do say that in that paragraph.
Then your dad's talking about the Rockets party. 3 times for violating the 10 Commandments. I'm assuming, do you know what 10 Commandments you were violating?
I don't remember I don't even remember the Rocket game.
Okay. Well, you responded to it. Not sure what this is about. Interesting that you would be discussing respect when you have shown none and continued not to show respect for your family. Now you told him again that he was disrespectful twice, right?
That's what it shows.
Okay. And number 12, in the next one, it says, I'm not making these statements as an attack on you, but a statement of fact. You want me to engage in an argument with you, so as you can prove you are right, I choose not to engage. And your response was that, again, how much do you care? Right?
Right?
But your dad cared enough to reach out, to have a conversation with you, and then to try to call you, albeit 4 hours after the conversation, and then to write you a letter. So it's pretty clear that your dad cared and was trying to get this resolved in 2007 with you.
First of all, I don't know about this. I don't know what the 4-hour situation was. Maybe we could look at that. I don't remember what this callback was, whether it was related to this letter or something else. So I really don't know about that, what you said about the 4-hour call.
Next one says, I found peace in my life. This is at a period of time when he's dating Lisa, correct? And he says, I found peace in my life. Correct?
He said that in the letter?
Right.
Yes.
And then your response to that was, congratulations on your selfish pursuit.
That's what I said.
What does that mean?
That means he, in my mind, I think, this is going way back here. I'm trying to interpret what I wrote, 18 years ago, but he's found peace, yet nobody else is finding peace. So as long as he's found peace, my reaction was, okay, well, you found peace, but you don't care whether we have any peace. That was the way I think that's what that was intended to say.
And then, let me see. I love you and all your family and your brother and sister, you care about them too. I am open and welcome positive dialogue with you. So here, he's inviting to have a positive dialogue with you and try to get this resolved, right?
Where are you? What page is this?
It's the last paragraph on the page that says 0000004. I love you and all your family, your brother and sisters, and care about them too. I open and welcome positive dialogue with you without anger. You see that?
Yeah, it continues.
Yeah, I'll keep going.
Okay.
But he's inviting you to have another conversation to try to get all this resolved and reconciled.
Yeah, I'm not sure that that's exactly what that means. I think that's what he wanted to say.
And at the end, he says, it says, and only hope you get help. And your response was such compassion. Was that sarcasm?
That was sarcasm.
Why was that necessary to have a sarcastic response to your dad?
Because I think he's the one who put me in a situation where I needed help, and he just helped. He was just hoping that I would go get some help, and I didn't think that was a compassionate statement. Again, I'm interpreting something here, so I think that's probably somewhat accurate of what I was saying.
So your dad put you in a position to get help because he was dating Lisa.
And everything surrounding that, yes.
We can set this aside now. Besides your dad, is it clear based on this letter, you can say yes or no, that your dad was trying to reconcile with you? He was trying to create space.
I don't think that's what he was doing.
To try to have a healthy kind of environment to be able to work all this out.
I don't think that's what he was doing with this letter.
Okay. And then isn't it true that David Mintzberg also tried to get you and your dad together to talk through some of these issues, correct?
You said also. I don't know what also meant right there. David Mintzberg and my dad did. David Mintzberg tried to mediate the situation, if you want to call it that.
Okay. And then also, you heard Dan Pappas say that he also tried to.
Yeah, but I don't recall Dan Pappas saying that. I mean, I think he may have mentioned one thing to me when I was in his office for my mom had gotten her leg broken and he was taking care of that. And I don't remember him really, he made one comment to me, but I don't remember him really mediating. I heard him say that, but I just don't recall him mediating anything.
Okay. Is it, I heard you say that you engaged in an enterprise with him, but it was one project, correct?
That's correct.
Okay. And you, I think, emailed him a couple of times, but not a lot from this period of time up until the time he died. Is that correct?
I'm sorry, what period are you talking about? From 2006?
2015. I think you touched about 2006, but let's limit to 2015 till the time.
Yeah, I know. I've been pretty clear about that.
Okay. And then I think you asked your dad to help you on issues related to the Greek citizenship. So his granddaughter could go.
Yeah, I don't know if it's helped me. I think I was collaborating with him to let him know what my daughter was doing. And I think it was, where were you? And it was really a dialogue over something that I think we both found important in a family matter.
Your dad play in Greek? Did your dad play in Greece? Did your daughter play in Greece?
No, they play internationally, not in Greece. They played in the Netherlands last year and the Prague this summer.
Okay, but your dad never got to go to one of her games, did he?
No, he did not.
Okay. It seems like a very one-sided relationship where you ask for something from him, he provides it, but then there's no reciprocity. No, hey, Dad, why don't you come to one of these games? That would be wonderful. That never happened. You got what you wanted and it stopped.
I really didn't get anything I wanted.
Oh, okay. In 2015, there's a copy of a document that we have referenced as a 2015 will. Are you familiar with that?
I'm familiar with the reference to a 2015 will, yes.
And you're familiar that Dan Pappas referenced the 2015 will, correct?
If you said so, okay. I don't.
And Monty Donaldson referenced the 2015 will, correct?
Okay.
Okay.
Yeah, I think they maybe have.
And I think I asked you before, I'm gonna give you another opportunity. You'd be surprised that your dad would disinherit you in 2015. Have you said that before?
I don't think so.
Would it surprise you if your dad had the intent of disinheriting you in 2015?
You know, my dad did a lot of things. It wouldn't surprise me.
Okay. So let's go and look at the will portion of this. This has already been pre-admitted as exhibit number 2. If you look at D in Article 1, it says, "It's my intention by this will to dispose of all my property." You see that?
I do.
And then E says, "I intentionally made no provision for my daughter, Christy Ann Polydorus." You see that?
I do.
Do you have any understanding of why your dad, other than saying things that he might have said, do you have any understanding why your dad might have made that statement?
I don't.
Then he says, "For purposes of this will, she and my son, George Nick Polydorus Jr., shall not be considered my descendants, issue, or child." You see that?
I do.
Okay, as you sit here today, you're not telling the jury that surprises you that your dad would disinherit you in 2015.
You know, he might have.
Okay. Let's talk about 2022. And I know this is probably hard to answer some of these questions, but your dad was in the hospital, right? Yep. You knew he wasn't well, correct?
That's correct.
You knew that he could have died, correct?
I think there's a possibility. Yeah.
And yet you still didn't go and see your dad.
That's correct.
After your dad died, you filed a will contest, correct?
That's correct.
Look at the 2022 will. You're an attorney. You may or may not know. Do you know what a no contest provision is?
Yeah, I've heard of it. Yep.
And what we're going to do is I'm going to put it up on the screen. I don't know if the jury has seen it before. What? Oh, they have found a copy. For the jury's benefit, you turn to page 8K. See 8K, no contest clause?
I do.
Says, "If any beneficiary hereunder shall contest the probate or validity of this will, then all benefits provided for the beneficiary are revoked." You see that?
I do.
Okay. And is it fair to say that because your dad included this no contest provision in his will, that he didn't want anybody contesting his will?
I think this is considered boilerplate.
You think this is considered, what do you base that on, that this is considered boilerplate?
Because I think it's in all wills.
You think it's in all wills?
I mean,
What makes you think it's in all wills?
I don't know. It just seems like it's something that you see in most all wills.
Okay, you're an attorney, but you haven't practiced in a long time, correct?
No, I still practice, but
Okay, you've never done a will.
I've seen these
You've
provisions.
never drafted a will.
That's correct.
That's right, and you never assisted anybody with the probate of an estate.
That's correct.
But still, as you sit here, it is
Mhm.
your testimony, even though you're not an expert, that that's just boilerplate in a will.
No, I think this is a boilerplate provision in wills.
Okay, would it surprise you if it wasn't a boilerplate provision in a will?
No, it wouldn't surprise me. That's just my opinion.
would it surprise you if your dad intentionally put this in here in his will?
No, it wouldn't.
And it wasn't boilerplate.
That wouldn't surprise me.
So again, by your dad putting this no contest provision in his will,
Mhm.
it's pretty clear that he didn't want anybody to contest his will, correct?
Yeah, I mean, it depends on whether he knew it was in there.
Non-responsive after, yeah.
Same.
And when he says nobody to contest his will, or he doesn't want anybody to contest his will, that would include his children, correct? Yes?
It would include the beneficiaries.
Okay. It would include his, I didn't ask that question. I asked you, would it include his children?
And I think the children would be beneficiaries under the will.
All right. Then if you go to the last sentence, it says, that here's kind of the punishment. Each benefit conferred herein is made on the condition precedent that the beneficiary shall accept and agree to all of the provisions of this will, and the provisions of this section are an essential part of each and every benefit conferred herein. Do you see that?
I do.
Okay. Let's go back and look and see, what did you have to risk losing by following your contract? Turn to page 2:6. You see 2:6?
I do.
Says, to my son, George M. Polly George Jr. and his wife Chrissy, or the survivor, a one-time payment of $2,500, correct?
I see that.
Okay. So if it's true that you contested this will and you lose all benefits under it, your risk is $2,500. Right?
Apparently so.
Okay. But if Chrissy and Dorothea would have challenged this will, at least initially, they risk losing more. Let's look at paragraph 3. To my daughters, Dorothea and Chrissy, is the ambassador condo unit. You see that?
I see it.
They would have also received $14,000. See that?
I see it.
And they would have also received $25,000. Is that correct?
I see that.
So they would have risked initially. Let me bring this back. Initially, you were the only one that filed a will contest, correct?
I was the only person who filed the will contest initially.
Okay. And the reason why, before you filed it, you and your sisters all got together and talked about finding an attorney to represent you to file a will contest, correct?
I think I found the attorney to represent me to file the will
You
contest.
deny there were texts back and forth about who.
No, I don't deny that, but I think I was the one who reached out and got and hired the attorneys.
Okay, and they didn't make any suggestions about who could be hired as an attorney? You don't recall that?
Oh, yeah. I'm sorry. You're right. I think my sister asked me about Jeffrey Horowitz, who I called, and that's how I got a hold of Vance Christopher.
Okay.
Yeah.
So at the time you filed the contest, or before the time you filed the contest, you and your two sisters were working together to identify an attorney so you could file a will contest, right?
Possibly, yeah.
Okay. And then once you met with the attorney, it wasn't just you, but it was also your two sisters that met with the attorneys on a couple of Zoom calls to talk about this contest, correct?
We all were on a couple Zoom calls, yes.
Okay. And isn't it true that they provided most of the factual information to be able to file your will contest?
Well, when it came to Dad's condition, that's accurate.
Okay. And then you filed the will contest, but they didn't, correct?
Initially, initially I filed it.
You remember it was after you filed the will contest that they finally joined the will contest?
I don't recall. It was a little while later.
8 months, 9 months?
Whatever it is, yeah.
And during that entire 8 to 9 month period, you and your sisters continued to work together on your will contest, pursuing your will
Judge,
contest.
I'm going to expect us to provide more product on this, and if we could approach, I'd appreciate it. The timeline is between when people retain attorneys and align.
Yeah, why don't you go ahead and come on up here and we'll talk about it.
So the worst way to say my question was, up until the time your sisters joined your will contest, correct? That's what I'm asking.
I'm sorry, would you restate the question?
Sure, let me do this. I think you said earlier that your sisters didn't join the will contest after you filed it for about 8 months, correct?
It sounds right.
Okay. And my question to you was, isn't it true that you and your sisters continued to work with your attorneys behind the scenes on your will contest for that period of time?
Objection to vague as to date.
I don't see any privilege issues yet. I don't know why the date is vague. You want to maybe clarify the date, I suppose, but I had a full understanding of what it meant. Overruled.
But again, I'm just asking about this 8-month period. We can talk about it from the date that, and you've already acknowledged, you filed the will contest, and then 8 months later, they joined the will contest.
Right.
This is the time period that we're talking about.
Okay.
Okay. During that 8-month period, isn't it true that your sisters continued to work with you and your attorneys on your will contest during that 8-month period?
And just for the record, Judge, I'm objecting to privileges. Any communication you have to do.
I understand. I don't think we're there yet, but duly noted.
Isn't that true?
Yeah, I would say they did assist during that period of time.
And the reason why they're doing that, and you understood, because you guys discussed this, is so they could avoid the no contest clause. Isn't that correct?
That may have been one of the things we discussed.
You're going to be asking this jury for attorney's fees, correct?
I believe that's what my attorneys have done. I rely on my attorneys for that, so I don't know what they're doing on that regard, but I believe we are.
The answer is yes. You're going to be asking the jury for.
You know, I'm not sure we've made these decisions. I think it's proposed, but I guess it's going to depend on the time we actually ask for them. I don't know if anything's going to change between now and then.
How much attorney's fee have you incurred in your contest?
I don't know. I think as of the last bill that I paid, it was around plus or minus 200,000
Okay. Now that's the last one you paid. When was the last bill you paid?
last month.
Last month. You're saying that your attorney's fees are $200,000 up until
I'm sorry, Ms. Kosicki, is this supposed to be up on your screen?
Sorry. No. I didn't realize this.
Don't look.
Did not realize I was.
Okay. I'm sorry. It's your testimony that up until this past month, so starting, I guess, February 1, the entire amount of bills that you have incurred has been $200,000. Is that correct?
I've kind of kept a running track in my head. That's where I think the number is.
Okay. That's where the number is, or that's where the number was?
I'm sorry. That's where the number is as of that date.
Okay.
Yeah.
Have you received any invoices between that date and now?
I think there's one outstanding invoice for something less than $10,000.
Okay. So as you sit here today, you think that you're going to be asking for $210,000 of attorney's fees from this jury? Is that what you're gonna do?
I think that's up through the date before the trial.
The day before the trial, it's your testimony.
I said that's through a date before the trial. I don't know exactly what date that is, but it's through a date before the trial.
Okay. So what I'm trying to understand, it's difficult. The day before the trial, how much date before the trial? Because you kept a running tab in your head, and I'm assuming you're getting bills.
Right.
So before the trial, between that date
Yep.
and the trial date,
Mm-hmm.
how much fees have been incurred?
I haven't looked at his work in progress. I would assume another 10-ish
You don't think it's another 100,000-ish?
between that date and trial?
Yeah.
Oh, you mean for like the prep of trial? I guess I looked at trial to include the trial prep. Yeah.
Okay, so 100-ish? I mean,
I don't really know. I haven't seen the bills. I haven't seen it. I mean, I'm sure we'll show our bills at some point, but I really haven't paid attention to the latest bills.
do you have any idea what amount you're going to be asking? Or is this?
I don't.
You have no idea. Let me just finish. Do you have any idea what amount you're going to be asking this jury for, the total amount, including all the way through the trial? Do you have any idea what that's going to be?
I do not right now.
Okay. Let's talk about what's at issue. All right, because if you spend $200,000 or $300,000, then you kind of want to know what's at issue in this estate. What do you think is the value of the estate subject to administration that you're fighting over?
We've been under the impression it's around $4.5 million.
Would it surprise you if that amount is actually closer to $2 million?
Yes, that would surprise me.
Okay. If you knew it was $2 million, would you have expended as much as you did in attorney's fees?
I might have. It just depends.
Do you think that the amount of attorney's fees that you expend, we haven't even gotten into your sisters, but the amount of money that you expended on this contest, your contest, if the value of the estate actually is $2 million, do you think that that would be reasonable?
Your Honor, I have to object. He's not been designated as an expert on attorney when this gets into the reasonable.
No, but he is asking for those fees, and he's one of the appropriate witnesses to talk about reasonable.
Okay.
Rule.
Yeah, so it turns out that the estate is actually $2 million or less, and you've spent $400,000 or more on your will contest.
Yeah.
Wait, let me finish. Do you think that's reasonable? A reasonable amount to spend 20% of the value of the estate on attorneys?
That's a hard question. I mean, I think that's just a hard question. I mean, you got to look at the facts. I really don't. I really don't know. I mean, again, you go through a trial, you work on it, you spend money, and it's hard for me to say that that there's one particular amount of money that you should spend to go and try something. It's hard for me to say.
Okay, but you've been monitoring these fees, right? You've been monitoring them
Yeah.
along the way, and you should have known what the value of the estate was, correct?
Well, that's a good question.
Just a yes or no. You should have known what the value of the estate was. Correct?
Yeah, it was my impression, as I said, that it was over $4 million.
And you think that you think that the $4 million is what was going to pass pursuant to your dad's will?
I do.
And because of that, you incurred the fees that you incurred trying to overturn the will, correct?
I don't know that I was comparing fees to the ultimate deal. I mean, obviously you do, and there's other things that you look into, but
Because it
Yeah.
really, it doesn't matter. I mean, you're still angry about all of this, aren't you?
no,
Okay, that's fine.
no.
Why don't we go ahead and take a lunch break at this point, and we'll come back about 12:45, okay?
All right, to the hearing.
Good, Judge.
All right, let me just turn everything off here before we go.
Gary?
May all be seated. And members of the jury, we're gonna go for a short time before our next break. I've got to stop at 1:30 to take care of some business. And it'll take me about 20-30 minutes, and then we'll start up again at 2. Okay? Just to kind of give you a preview of what we're going today. All right, Ms. Courtland.
Okay, George, why didn't you try to visit your father while he was in the hospital?
Main reason was there was a lot of protocols there, and you know, they weren't allowing a lot of people in, and I was allowing my sisters and others, but you know, it was my understanding that Lisa was kind of the gatekeeper, and I didn't think it would be appropriate for me to approach my dad through her.
And during that time, were you relying on your sisters for information regarding your father's condition?
I was.
When did Georgia start playing for the Greek national team?
It would have been 22 or 23, probably 2023.
Did your father ever have the opportunity to be invited to watch her play?
No.
And do you think we'd be sitting here today if your father had executed the 2022 will in an attorney's office or under other normal circumstances?
Objection, speculation.
I'll allow him to answer though. Overruled.
Sorry, would you rephrase that?
Do you think we'd be sitting here today if your father had executed the 2022 will in an attorney's office or under other normal circumstances
And not sick?
and not sick, correct?
Yeah, I don't think we'd be here today.
What was your primary reason for contesting the 2022 will?
My primary reason was for the benefit of my family, again, for my brother, for my sisters. My dad was such a family man, and he was taking care of them and would want to take care of them. And I don't believe that this will, in what was left for them, reflects what he wanted.
And how big of a factor is the fact that your dad was in the ICU on February 9th, 2022? How big of a factor is that in your contest?
I think that's a huge factor.
Ask the witness.
I have no further questions, Judge.
Mr. Cook?
How old were you when Lisa and your dad got married?
Judge, I'm going to object as beyond the scope of redirect.
What is?
I had 3 very narrow questions.
We're Texas, not federal.
No, but under 611, I've invoked that rule since the very beginning of trial. If it's not, you should have covered it in your direct or your cross.
Okay.
But on redirect, I don't think she covered this, so I'm going to sustain the objection.
Okay. Let me ask you this. It's your testimony that you didn't go to see your dad because of protocols and because Lisa, you'd have to go through Lisa, who was the gatekeeper. That's your testimony?
Yeah, that's primarily the reason. I wasn't going to go and approach her to go see my dad.
Have your sisters told you that somehow she precluded them from going to the hospital?
No, there was, as we've heard, there's only a few people allowed, and I wasn't going to intervene given the fact that I hadn't been there and try to get in there and become one of those with the limited amount of people allowed in the room.
Isn't it true that your brother Nick went?
I don't know.
Isn't it true that both of your sisters?
They went.
Isn't it true that your sisters spoke with staff about visitation and when they could visit?
I don't know.
So it's not Lisa that was a gatekeeper. Is that your testimony?
My testimony is that she was there 24/7, as far as I could tell.
You have any idea why she was there 24/7?
I know she was taking care of him.
She was taking care of her husband, right?
Yes.
And anytime that anybody wanted to visit, isn't it true that Lisa left so they could visit?
I don't know that.
You don't think that's what the facts are going to show?
They could.
And you've talked with your sisters about all of this and how they had access, and your sister even had access to my chart and had all his medical records.
Objection outside the scope.
Sustained.
You had communications with your sisters. They were the ones that were talking with Dr. Attar. They were the ones that had access. They were the ones who were communicating. There was no gatekeeper. What gave you the indication that Lisa was the gatekeeper?
I was under the impression that there need to be coordination, et cetera. I didn't think I had the ability to just go up there by myself.
Okay, and what gave you that impression?
Whether it was from them or anything else, it was COVID protocols. There was a limited number of people. She was there all the time. And I didn't have a relationship, that kind of a relationship with my dad or with her. So me barging in under those scenarios would not have been a good thing.
Do you think anybody on this jury would say, if that was my dad, I would barge in and go and see him?
Sustained.
I don't know what they would say. I'm just telling, oh, I'm sorry.
I'll pass it.
Sorry, Judge.
I'll pass it.
Okay.
Back to you, Ms. Gobadia.
Nothing.
Ms. Smith,
Nothing further.
thank you. You may step down.
Good, I think,
Yes, sir.
I'm next on attorney's fees. I
Very good.
do it the same way as that Mr. Cook did it. Okay.
I don't have any objection. Mr. Cook, any objection?
Yes, sir.
All right.
I am going to mark this. Do you know what it's? Yes. GNP. May I proceed, Judge?
As soon as you're sworn in.
Okay.
Over here.
Oh, sorry.
It's okay. You solemnly swear or affirm the testimony you're about giving this cause will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. You may be seated.
Now may I proceed?
Yes, sir, you may.
My name is Vance Christopher. I'm the lawyer, one of the lawyers for George Polidorus. I guess I'll tell you, I'm going to try to prove up my attorney's fees with my testimony today. It'll be very much like what Mr. Cook did. I've been practicing law since 1981. I was a prosecutor for 4 years, and then I did civil work. And around the year 2000, I started working in the probate realm. So I've been doing that for probably 25 years. I'm board certified in civil trial law. That's a designation you get if you try cases, if you've been around long enough and you pass a test. I used to be board certified also in personal injury trial law. But I had to give that up because I don't do that much. You're supposed to do 25% of your time in a specialty, and I wasn't doing 25%, so I had to give that up. The thing that was useful about personal injury law is I handled several brain injury cases, and the science of that is very interesting as it relates to guardianship and capacity issues. So I found that very interesting. You might not think personal injury has much to do with this kind of work, but it can. I've got some, as you can tell, Jessica Gorbadia has been working on this case with me. Jessica is, she's been out not as long as I have, and it's pretty obvious by the way I look, and looks a lot younger, that I've been practicing a lot longer. But she's very skilled in the estate, probate, will contest, administration in this court. She's a regular of these courts, has a lot of expertise in guardianship, a lot of expertise in will contests. and mental health docket, that sort of thing. That does a lot of mental health type work. What I will offer as GNP 24 is a list of invoices. And these invoices have been redacted. There are certain aspects of this. It's, I think you can see the blanks in there. That's redactions, and those are generally because the material is privileged, attorney-client privilege, and so we redact that to keep it from everybody. That's privileged communications that we have with our clients. The invoices will show that there were several different timekeepers working on this. We had several paralegals. We had several different younger lawyers, associates who worked on it, and their names will be abbreviated. And then the names, you'll be able to trace the abbreviations to the names, like Rhonda Hansen, Sylvia Lopez, Monty Holmes, Michelle Martin, Maria Carlson, Haley Devine. Those are some of the paralegals that we have in there. And then Chris Winnicki, Keith Taylor, Suzanne Perry, Trey Gifford, he's GTG, I believe. Jessica is JLG, Amelia Harvey. Those are the lawyers. And I know the lawyers, and I've worked with them, and I've looked at the timesheets, and they appear to be reasonable and necessary, the time that they spent and the rates that they charge. I will tell you, I guess I'm a 40-something year lawyer now, 43, 44-year lawyer. The rate that I have charged in this case is $550 an hour. I have written my time down. Jessica and I are both working on the case, and I've tried to avoid and tried to minimize duplication on things. So there will be times when I have written my time off. That is, I've no charged it. If there's an NC, I've no charged it. It's not astronomical, but I've tried to be careful. And I think I saw that Jessica had done the same thing in some of her billings. So some of that I have written off, like on I think it was on the mediation, what I tried to do, and I think it's reflected in these documents. We had a mediation date. And both Jessica and I attended. I did not bill my time. I wrote it down, and then I no-charged it because I didn't think it would be quite fair. I mean, it could have been. Jessica and I both worked on the case, and we both had input in the mediation, but just felt like I couldn't charge you for both. Now, having said all that, I don't want you to think that I'm a saint and I'm doing this for free. I'm not. I'm charging a big fee. I charge higher rate on other cases, but I looked at this case and the type of case it is, and I adjusted my rate down somewhat. And I do that often. I don't always charge like $725 an hour. I think that's really high. It just depends. It has to be I don't do that very often. So I adjusted my rate down to $550. I think Jessica's was $475 or something like that. I think those are fair rates, and the rates that I looked at in here for all the timekeepers seem to be reasonable and fair and customary in and around Harris County. I also, when I give the total, let me just go ahead and give the total. What I've done is, as you might expect, we're still working on the case, and we're going to continue to work on the case until it's over one way or the other. And so what I did is I ran the bills, and I think in Exhibit 24, the bills end. Well, some people got their time in for yesterday, through yesterday, but not everybody. So it's pretty current, but it's not completely, it's not what it's going to be when the trial is over. So what I've done is I had my accounting department, and it took a little effort to get it right. I think I got it right. I hope I did. I had my accounting department pull a current bill, and then run a total on it. And the total on it, let's try to put this in a category. And again, it follows along with what Mr. Cook did in his category. For trial, the trial expenses through yesterday or Saturday at least, the trial fees and expenses are $339,495.93. Now, what I did in order to get to that is I took the fees and expenses, and the fees I discounted, again, this is kind of similar to what Mr. Cook did. I discounted them 15%, and I cut the rate of Terry from down to $200 an hour. And the reason I cut her rate down is not because she's not up here working hard, and you'll see her hours are pretty heroic. The reason I did that is because, and this is my fault, I did not communicate with her as clearly as I should have, and so some of her efforts may not have been to benefit the client as much as I would have liked, and it's not her fault, it's mine. And so I reduced her time. If you guys want to punish me and reduce my rate some more, that's fine also, but that's what I was thinking, and I was thinking the 15% discount would help with George, because this is a lot of money. And and he said something. He said, you go to trial and you got to defend the case, or you got to prosecute the case, and you've got to try to do it right. And that's what we've been trying to do as hard as we can. And it's not easy. It can be kind of hard. It's a lot of work. So as Mr. Cook said in his testimony, this is a hard-fought case. And we had to go out and get the medical records, which you've seen boxes of 14,000 plus pages. We had to get texts and records from law firms. And so we had to spend a lot of time. We had to hire Dr. Merkel to look at the medical records. I mean, we can look at them and things may mean something to us, but we need an expert who can look at the records and say, you're right, you're wrong, this is what this really means. And so that's what we did with Dr. Merkel, and that was not cheap. And we had to spend some time with him, finding out what his opinions were and why, whether we had a case or not. So we really felt like that we had to do a lot of work to get the documents, including the medicals, and spend a lot of time to go over them in order to determine and try to bring that case to you. There was, and let me just say, this is something that I have to do. It's part of the law. It's what the law requires. And again, you heard it from Mr. Cook as well, the same sort of thing. And so what this Exhibit 24 is the records reflecting the time and expenses, the fees that were charged in this case, George Polidorus, based on our representation. And so that's what Exhibit 24 is. And I'm one of the lawyers at the firm. I'm a custodian of the records under the law, so I can say that these are the records from the firm. I can bring them to the court, offer them into evidence. And in my opinion, these fees were reasonable and necessary in order to pursue this will contest and try to get to the bottom of what happened in that ICU unit on February the 9th. These are itemized statements showing the work, the fees, the services, the expenses for our firm and the lawyers and paralegals at our firm. That is Exhibit 24 is. All this work was done by me, Jessica, and the people who helped us out. There was a time, I mean, there's a pretty long list. There was a time when it got busy. We thought we were going to go to trial on February the 5th, and it didn't go on February the 5th. So we geared up and brought kind of all hands on deck, and then it didn't happen. And then we were set for March the 24th, I think it was, and we geared up again. So that may explain some of the ebb and flow in all of this. And just so you know, as far as ebb and flow, I started out on the case, and Jessica, I brought Jessica in because of her expertise and her experience in the area that was specific to this kind of case. And so I started out, and I was pretty involved in the drafting of the pleadings to try to get the pleadings right and get them accurate. And then at some point in 2023, maybe around August or so, I backed away, and Jessica and I think Laurel did most all the work. And then as the case got closer to trial, for better or for worse, I injected myself into the process and said, hey, let me help try the case. And so I got back into it late 2024 and up until the time of trial. So in my opinion, I think the work that we did was reasonable and necessary. To the extent some of it wasn't or was repetitive, we tried to no charge it or not bill for it. And to the extent we missed something, I thought tried with the 15% discount to try to make up whatever we may have missed. But I think when you look at all of it, added together, it's reasonable and necessary to protect and to pursue the interests of our client, George Polidorus. And I think it's relevant and consistent with the attorney's fees and expenses that are spent in this county on this kind of case. Again, it's a hard-fought case. You may have been able to pick up on that a little bit, but it's a hard-fought case. Based on my years as a lawyer and my training, I mean, I went to law school and graduated in 1981 and majored in economics, then went to law school and then immediately started doing trial work at the DA's office. And based on these records, I think the fees that we expended are reasonable and usual and customary, and the amount of hours are reasonable and usual and customary for the work that we had to do. And this takes into account, and these are things that I need to look at and get into evidence. Taking into account the time and labor involved, this is very time consuming. The nature of issues raised in this case, which are some, at least in one sense, complicated. You've seen the expert testimony on the medical records, and that you can make that call, but I think it was fairly involved. The nature of the issues, the skill required to perform the legal services. I mean, I think you kind of have to know a little bit, like Jessica does. You kind of have to know a little bit about this in order to kind of anticipate how it's going to play out and how to try a lawsuit. The preclusion of other employment by the lawyers due to this case, that means you can't be in two places at once. So we're doing this, we can't do something else. The customary fee in cases like this in Harris County, and I think this is pretty consistent with the customary fee in Harris County for these kind of cases. The nature of the fee arrangement, it was an hourly arrangement. You can see this in here, the hours and the hours and the rates are reflected in here. And my accounting guy added it all up, and that's the totals that I gave you. The time limitations imposed by the case, well, it's been very time consuming, but got to do what you got to do. The amount in controversy, I think the amount in controversy justifies it. But it's not just the amount in controversy, it's also what happened and what George felt like he needed to do. The experience, reputation, and ability of those involved in handling the case. I think Jessica has a sterling reputation in this area, has a ton of experience. And, you know, I don't know, I'm a member of a couple of organizations, trial organizations. I worked on the pattern jury charge committee for probate and family law, 2009. You know, haven't been on it in several years, but I did work on it. And the pattern jury charge is the questions that lawyers, it's a book that has the questions on this kind of case, for example. There's many different kinds of cases, but they have potential questions that a judge might ask a jury in this kind of case. And so I worked on that committee, and for better or for worse, I learned something about it, and I was part of the committee that kind of drafted the original probate code. It's the estates code now, but the probate PJC. I do not claim to be some super expert in the arcane ins and outs of the estates code. That's not my highest and best use. That's more Jessica's thing. I'm more the trial side. I'm a member of the Texas Board of Trial Advocates and maybe something else here and there. It's in my CV, but anyway, I've been trying cases for a long time. Considering these factors, the amount charged for the services shown in Exhibit 24, I think they were reasonable and at the time and the place that they were providing. Now, these records, again, I'm the custodian, and these records, I mean, we keep these records on all of our hourly cases. That's mainly what we do at my firm, is keep hourly records. So that's something that we do all the time. We participate in creating these. We do these. We write our time entries, describe what we did pretty much at the time. And that's what I do, and that's what I tell all the lawyers to do. Do it at the time. maybe you can be very accurate if you do that. And it was transmitted through the system, through the regular course of business by the timekeepers in this. And they had personal knowledge on what they did. In other words, they knew what they were doing and they wrote it down as they did it. They were made, again, hopefully reasonably at the time or reasonably soon after the time that they provided the service reflected in there. And except as redacted, the records are an exact duplicate of the original. I will say we had an early version of this, an exhibit that I was looking through the middle of the night last night, and it was not in the proper order, so I reordered it and there were duplications, and hopefully I fixed all that up. And this exhibit 24 is an accurate, organized, and hopefully clean copy of our records. Now, it says the legal fees could increase. So what I did is, since we're not over yet and we're not finished yet, is I put an estimate of time for me and Jessica and for Terry, 8 hours at $400 an hour for me and Jessica, 8 hours at $200 for Terry, and that comes up to about $8,000 per day for the days that we have not covered in this. So that's what we'll be asking for. I think that's pretty conservative. Also, the Court of Appeals, Mr. Cook talked about this on appeal. There are blanks for the Court of Appeals. And what I did was essentially is I figured out, tried to talk to one of my appellate lawyers. Henry Collenberg is an appellate lawyer, Stanford undergrad, Harvard Law School's board certified in appellate law. And I asked him what would it cost to go to the Court of Appeals, and he said, like Mr. Cook, $30,000 to the Court of Appeals. And then I talked about petition for review to the Supreme Court, and he said $20,000. And for these are categories that you'll see later in the trial from the judge, I think. And then for briefing on the merits to the Supreme Court, that's another $20,000. And then oral argument to the Supreme Court is about $25,000. And so the way we figured that out was his rate, he agreed to drop his rate to $550, and which is the same as mine. And so we just multiplied 550 by the number of hours. So the number of hours times 550 get to 30,000, 20,000, 20,000, and 25,000. So that's how we figured it out. Henry and I worked on appellate cases before, talked to him about the case, told him about the issues, and that he thought that these amounts were conservative, that it could probably take a lot more. But for example, if nobody appeals, then they're not relevant. Nobody gets that on. If somebody appeals, but it only goes a stage or two, then you stop. You don't spend all that money, and you don't get them. Okay, Your Honor, I will ask my co-counsel. I think we're done. I'm through with my direct of myself. Judge, I think I'll pass myself to the next lawyer.
I appreciate it. Ms. Smith, any questions of Mr. Christopher?
No questions, Judge.
Mr. Clerk?
Christopher. Your firm worked with, you represented George Polydorus Jr., right?
Correct.
But your firm worked with Christy and Dorothea for about an 8-month period before they joined the lawsuit, correct?
I don't know. I might not have been involved in that. I'm not disputing what you said at all. I'm just saying I'm not sure I was that involved, but I'm sorry.
Yes,
please. Come on up.
Mr. Christopher, I don't have to go way down 8 months, but I mean, isn't it true that you participated in a Zoom call with all three of them?
I don't know if I did. I might have, though.
Okay.
I might have. I just know this is about the time that I kind of backed away and wasn't as active.
But if I go back and look at your invoices, I didn't see any notations where you spoke with anybody other than your client.
That may be because I didn't. I just don't remember that. Again,
Okay.
it would be fine if I did. I don't care if I talked to him. I'm glad to tell you hypothetically why I did talk to him.
Well, the facts bear out that you were on a Zoom call and talking with them, and there was at least 2 Zoom calls before the contest was filed, then you just don't remember.
I would not remember that. I remember them, and I know they knew things that George didn't know, but other than that, I don't.
Okay. And you said you wanted to avoid duplication, correct?
Try to, yes.
That's important, right?
It is.
Did you try to avoid duplication between Keen Miller and your firm?
We've tried to split it up in a way that there was not duplication.
I mean, if the jury sat here for the first couple of days and saw that you guys were asking a lot of the same questions, I mean, they would be able to determine for themselves whether there was duplication or not.
Right, to the extent it wasn't effective, yes.
Right.
And they could punish us for it if they wanted to. I agree.
Thank you. And then what you're asking for is 339,000, but you're saying, but there could be more. Is that correct?
Well, there will be more time spent. I think you said this about your time as well.
I cut my time off.
Okay, there will be more time spent.
And I'm asking you the question, is there going to be more fees than this $340,000?
Well, we will have incurred more time, and it will be more than what I projected, but yes.
How much more do you think you're gonna expect?
Well, I think I blackboarded it at something like, I think it was $8,000 a day for me and Jessica and Terry, as I recall.
So maybe another 2 or 3 more days?
It depends on how long the case, yeah, however many days.
So could it be as much as another $25,000? So we could be at $360,000 by the end of this.
It could be.
Okay. And this is, just to be clear, this is just George Polydorus's junior's fees, not also including the other fees.
Yes, that's right.
Okay. Earlier you testified, I think what you said was, you were talking about the amount involved. Do you remember that?
The amount involved, yes.
Right. And the way that you presented it to the jury, you said the amount involved and what George needed to do. Do you remember that?
Yes.
Okay, but that's not the test. It's not the amount involved and what George needed to do, it's the amount involved, correct?
It is that. That's not the only element, though.
No, there's other elements, but none of the other elements include what George needed to do.
Well, I mean, the whole list of,
I'll read you these if you like.
I'm
None of them
reviewing them
include,
too.
you agree with me, none of them include what George needed to do.
That's not true.
It's not.
I don't think so. It is included in the language. I think it's
Okay,
in.
let me read this. 1, time and labor required, the novelty and difficulty of the questions involved, and the skill required to perform the legal service properly. That's 1, right?
Sure.
Okay. The other one is the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment of the lawyer. That's the other one, right?
Well, that's one of them.
But well, that's 2 of them. We'll keep going. The other one is the fee customarily charged in the locality for similar legal services. You see that?
Yes.
So another one is the time limitations imposed by the client or the circumstances, correct?
Right.
The nature and length of the professional relationship with the client, correct?
Right.
The experience, reputation, and ability of the lawyer or lawyers performing the services, correct?
Yes.
Whether the fee is fixed or contingent,
Yes.
and then the amount involved and the results obtained, correct?
Sure.
But none of those say, and what George needed to do.
Well, one of the issues, I think you
No,
look,
no,
no,
Yes or no, sir?
that would be misleading.
Your Honor,
Just say
objection,
yes or
no
no.
response. Just asking, just, none of those included, and what George needed to do.
Those aren't all the issues, though.
Okay, well, the jury will be able to look and see and make a determination for themselves. All right, now let's talk about the amount involved. How much is the amount involved in this will contest?
I don't know exactly. I heard my client say 4.5 million.
$4.5 million. Where did he get that?
You'll have to ask him.
Well, I
I don't
did,
know.
but you're the attorney involved in this.
I'm not sure you asked him how. I don't think that's right. I don't think you asked him how he got the 4.5 million.
Objection, non-responsive.
But
We're not having a discussion, Mr.
But you're misstating the record. He didn't explain the 4.5.
Your Honor, would you please direct the client, the witness, just to answer?
Okay, we all know how this works. Just answer the question. Don't volunteer any extra information. Your own counsel can come up with clarifying questions if she needs.
You'd agree with me that the amount involved is a factor, right?
It is.
So as the attorney who is testifying as an expert, on behalf of your firm, that you should be able to tell the jury what the amount involved in this will contest is.
Not necessarily.
Isn't it true that there's two properties listed in this $4 million that you're talking about that has debt against it of about $1.2 million?
Well,
I'm just asking.
I don't know. We'd have to get all the assets out and look at this. I don't know.
Would you?
That's not part of this, the issues the jury's gonna answer. I didn't ask.
Well, let's stick with question and answer format and don't overtalk each other, okay? Thank you.
I think we should object to fact, not an evidence as to debts and values and all of it.
None of those are in evidence. You're correct.
I will offer them now.
Okay.
May I approach?
Yes, but I'm going to sustain that objection until you offer them. Yes, I didn't, because I didn't say anything. Ms. Guabanius?
Then we have other, because that's misleading. Private.
That's a cross exam or sorry, redirect issue that you can come up with.
Right.
You may.
I think the 30-minute inventory, I'm assuming you've seen that report.
I have.
I think that you were talking about the $4 million number. If you'll turn to page 3 of 3. You see that?
I do.
And that value, that says $4.4 million. You see that?
Yes.
Okay. And if you look at number 1, it says one real property A, description, Memorial Turkey Creek. You see that?
Yes.
The value that's listed on the inventory is $916,000. Is that correct?
Yeah.
Okay. And then there's debt against that of $496,000, correct?
I don't know.
Isn't it true that your firm is the firm who handled the redoing of the credit on it?
I don't know.
Facts, not an evidence.
I'm sorry, he's asking the question, so it's not an evidence yet until there's an answer, but technically correct, yes. Go ahead, you can continue.
But didn't your firm?
I don't know.
You don't know.
I didn't work on that.
Okay.
This is way complicated. I didn't work on it.
This is complicated?
Well, the whole estate is. That's what my client said.
Okay, this is a 3-page inventory, correct?
But that's not the end of the universe as far as I know. I don't know. I haven't been working on the inventory aspect of it. I've just seen big general numbers and talked to my client.
And you, I guess, as you're sitting here today, you have no idea there's about $500,000 of debt against that.
I don't know what the debt is. I don't know what all the assets are.
So if there's debt against it and there's $4.4 million of value here, wouldn't you, when you're trying to figure out what the value of the estate is, wouldn't you reduce value by the debt?
You might.
Okay, so now we're talking $3.9 million.
It's not what I'm talking about. I just don't know.
If
I
you
don't know
look
if
at
there's
the
other assets.
objection on response,
Sustain.
if you look, turn to the next page.
Which page number?
2 of 5.
2 of 5.
It says DGLA 26 LLC. Do you see that?
I do.
Okay.
Is that number E or letter E?
Letter E. And it has a value of $1.163 million. Do you see that?
Yes.
Okay. And then the debt against that property is
Objection, perhaps it's been off. Facts, not an evidence.
The inventory is not been offered, no.
Then I object to facts, not evidence. After reading of the document.
I'll offer it as soon as.
Sustained, thank you.
Okay, Your Honor, Mr. Christopher was looking at a 30-minute appraisal and list of claims, and that is a certified copy, and I would ask that that be admitted as exhibit number.
You are on 17, I think is your next one. Oh, there's-
Is this one from executive?
I'm sorry?
What is it?
It's that.
I'm assuming this is Lisa Polydoros's exhibit list. Number 18. Is there any objection to the inventory? Not hearing any objection, that's admitted.
Next meeting?
You may.
Thank you. All right. So from the 4.4,
I'm sorry, maybe a-
Sure. Come on up. All right, so I'm going to renumber that exhibit. It's exhibit number 17, Mr. Cook.
we started with 4.4 million, and then there was 500 debt, and we're down to 3.9. Were you aware that the EGLA 26 has a debt against it of $700,000?
I don't know what the debt is. Thank you.
Don't you think that's important to try to determine what the value of this estate is?
It would be relevant to the value. Yeah.
Okay. If I deduct 700,000 from the, I guess, 3.39, we're at 3.20. Is that correct?
I don't know.
Okay.
You deducted 700 from what, 11, 1.1?
3.9. So we're 3.2. There's another asset on here. You look at exhibit F.
Okay. In there.
That is not a probate asset. That is not subject to this lawsuit, correct?
Objection, relevance, and outside the scope of his expertise.
I think we're talking about the value of the estate.
He's asking for a characterization of the.
He is, and if he can prove it or not, or you can disprove it, that's up to y'all to figure out. This is just getting at a value. Overruled.
I mean, isn't it true that $700,000 asset is not a probate asset?
I'm not sure because this is disputed, I believe.
it's a dispute that is a probate asset? Is that what you're saying?
I think maybe you're saying it isn't,
Oh.
we're saying it is.
I'm sorry. I've got a hard stop at 1:30.
Okay.
So, why don't we pick up there? Let's let the jury go back and let me take care of this little quickie business I need to take care of. I apologize. I know it's right in the middle of your questioning and I don't mean to interrupt the flow, but I do have to get to this other thing. All right, so we're gonna let you go for about 20, 30 minutes. We'll come back at 2 o'clock.
All right, so jury,